So as introduced, my name is Catherine MacWillie. I am the CEO of Custody Calculations, Calendars, and Orders, a Public Benefits Corporation. I will be presenting on, clicker? Got it. On law enforcement and parental alienation. Before I begin, I would like to provide the following information. My experience, background, and training is that of a law enforcement officer. My presentation is based on that perspective. I'll be covering 4 areas in my presentation this morning. 1, family law from the perspective of law enforcement, including crimes and crime percentages. 2, social services, including false allegations, police reports, and restraining orders. 3, law enforcement policies that benefit the alienator. And 4, parental alienation and court from the perspective of law enforcement, and closing comments. A packet will be distributed at the conclusion of my presentation with a copy of my script today. The packet also includes some information on the University of Laverne Extended Learning Program, while I'll be teaching Navigating Family Change, Dealing with Divorce and Custody. I believe this is the first such classes offered at a university level, and it took me several years to get that in place. I have 34 years dealing with family law, 24 years as a law enforcement officer with the LAPD. I responded to radio calls dealing with divorce and custody, and was a first responder to child abuse investigations, as well as other assignments impacted by family law. I conducted 10 years of research into the cause and effect of family law. The last 10 years, I've been a child custody and divorce coach. I have clients all over the United States and abroad.
There it goes.
No, that's okay, I checked it out. Okay. This is an actual recording of an emergency response by law enforcement. This is what divorce and custody sounds like to law enforcement officers throughout the country. Excuse me. On January 26, 2005, at 6:03 in the morning, Juan Alvarez, depressed over his pending divorce, slashed his wrist and stabbed himself in the chest in a failed suicide attempt. Determined to succeed, Alvarez came up with the brilliant idea to park his vehicle on the railroad tracks, believing he could not fail in his next attempt. As the train approached, Alvarez changed his mind, but was unable to start his truck and move it off the tracks. Instead, he jumped to safety, while the crowded commuter train struck his vehicle, which was still on the tracks, and was derailed, injuring over 200 and killing 11. In August of 2008, Alvarez was convicted of special circumstances and received 11 life sentences with no chance of parole. No one on that train had ever heard of Juan Alvarez before that date, yet all were impacted by his divorce long before he ever set foot in a courtroom or stood before a judge. His actions created a ripple effect that no passenger on that train will ever forget. No prior criminal history was referenced in any of the articles that I reviewed on the case of Juan Alvarez. Katz, Texas, August 27, 2004. The Rick Lowenstrauss shooting. A young 10-year-old boy sitting in the rear seat of his father's vehicle removed a handgun that he had taken earlier from his mother's residence and concealed on his person. The boy then fired several shots to the driver's seat, killing his father, believing he had been abused by his father. The incident occurred during a custody exchange outside the mother's residence. Numerous allegations of child abuse had been filed by the mother against the father. All the allegations were closed with no finding of guilt. The father was an emergency room doctor, the mother a nurse. Physicians rallied around the child as a victim of parental alienation syndrome. The case made headlines around the country due to the child's young age, and for the first time, the term parental alienation syndrome was heard by the general public. The child was ultimately convicted and sentenced to 10 years to a juvenile facility. At age 16, he was released on appeal to his mother's care over the objections of the grandparents on the father's side who had sought custody of the boy. As expected, for a child of this age, no criminal history was referenced in any of the articles I reviewed on the case. Now, Sean, who I was speaking to on Friday, gave me some information that I did not originally have on this case, which was that at the time of the shooting, the child was heavily medicated 4 times over his dosage of Prozac. For a child his age, his mother, like so many alienators, mothers and fathers, sought therapy that supported her position and that involved medication for her son. Child homicides are the most difficult, not only for officers, but for everyone tasked with these investigations and prosecution. The story of Sam and Libby Porter is no exception. It was, in fact, particularly difficult for me to speak of their death in 2007 for a long time thereafter. When speaking about Sam and Libby, who were only 7 and 8 years old at the time of their death, I would pause momentarily before speaking about their homicide to avoid becoming overly emotional. Then I would have to pause a second time after saying their names before providing the details of their death. With the passage of time, only have I been able to speak more freely of this incident. Now, in part, that's due to my own experience in dealing with another homicide of 2 young children in the division where I was assigned as an officer. About a year prior to my retirement, a father upset about his pending divorce took his 2 young children, a little boy, age 5 years old, and his daughter, and 8 years old, and pinned them each under his arms like in a headlock. So he's got his 5-year-old son on one arm and his 8-year-old daughter. The father then slit the throat of his son with a knife using the same arm that was restraining his daughter. So he actually placed his daughter only inches away from that of her brother when he died. Now, she was only 8 years old, but she fought to live as she watched her brother bleed to death. She wanted to live so badly that she struggled to do so even at this young age. Still tough. We know this because in the autopsy, it revealed that her neck was jagged from the slits because she struggled so violently while the little boy's throat was slit neatly. I still remember exactly where I was standing that day when the mother came into the station. Excuse me. Those of us who saw her enter the station knew what awaited her, and her scream could be heard throughout the station when she was given the news. It haunts me still, as does this case, and too many others like it. So when people ask me why I do this, this is why. Okay, although I've spoken about this particular incident in conversations, I have never spoken of this specific homicide in any presentation before today. The image of this little girl fighting her own father to live, even at this tender age, and the jagged cuts on her throat has just been too overwhelming even for an officer as seasoned as myself. Now, going back to Sam and Libby Porter, they were from Independence, Missouri. On September 28th, their father picked them up for his parenting time, and they were never seen again. Sam was 7 years old, and Abby was 8. After the father's initial arrest on kidnapping charges, he told authorities several stories about what he had done to the children. He said he had strangled them. Then he said he had cut them up. The mother said the father had tried to get her to go into the woods with him, telling her that he had stashed $50,000 in the woods and wanted to go get it. She refused to get in the truck and go with him, and it's likely that had she agreed to do so, she would have been killed as well. Court documents reveal that the father told authorities that he had been planning to kill his children several days in advance of his parenting time. The father was convicted of parental kidnapping with the specific intent to terrorize the ex-wife and was sentenced to 38 years in prison. After being convicted, the father, his voice choking, said, "I can't get them out of my mind." Asked why he did it, the father said, "Could any man come up with an excuse for that? Is there an excuse? Is there such an excuse?" The father had refused to provide any information on the whereabouts of the children's bodies during the trial, and in a rare decision, the conviction was obtained without the physical remains of the children. Only upon the threat of being released into the general jail population after his conviction did the father finally tell authorities where he had buried the children. The children's remains were identified using DNA, and the autopsy confirmed that the children had been shot. In exchange for the information of where the children were buried, the father was placed into protective custody in the prison system. Anyone convicted of a crime against a child will find that prison can be very dangerous and in some cases deadly. Even prisoners have a code of ethics when it comes to children. No prior criminal history was referenced in any of the articles I reviewed on the case by the father on this conviction. Fulshire, Texas, June 27, 2016. Jason Sheets thought his wife was going to tell their two daughters, Taylor, 22, and Madison, 17. And by the way, Taylor, the oldest daughter, was pending a wedding just in the week following the shooting. Jason thought that the wife was going to tell the children that the parents were getting a divorce when they all met at the house for a family meeting. Instead, the mother pulled out a handgun and fatally shot her daughters, chasing one of them into the street. One daughter died on scene, the other died at the hospital. The mother was shot and killed by officers when she refused to put down her weapon. The mother had ample time and opportunity to kill the husband, but chose not to. The father felt that it was so that he could live every day the rest of his life, suffering over the death of his two beloved daughters. No prior criminal history was referenced in any of the articles I reviewed on the mother. Articles did reference, however, that at the time of the shooting, she was being treated by a therapist and she was on anti-anxiety medication. December 4th, 2008, West Covina, California, dubbed the Santa Claus Massacre. Oh, you know what, I apologize.
It's a harrowing 911 call.
This is National Radio Call from the prior incident.
It's a harrowing 911 call.
I promise you whatever you want.
Then the mad mom's chilling voice can be heard cutting through the chaos.
These 911 phone calls are some of the most disturbing that you can imagine. The screaming, the desperation, the sheer horror in the voices.
We played the 911 calls for noted criminologist Dr. Casey Jordan.
She knows exactly what she's doing. She is methodically doing.
West Covina, California. This was dubbed the Santa Claus murder. 45-year-old Bruce Pardo, angry over his divorce and custody settlement finalized only 6 days prior, wearing a Santa suit, disguised himself and entered the residence where his ex-wife and her relatives were celebrating the holidays. Hidden within the Santa suit were 4 semi-automatic weapons and an incendiary device. When Prado left the residence, the house was engulfed in flames. Dead were 9 family members, including Pardo's ex-wife and her mother and father, who had recently celebrated their 50th wedding anniversary. Pardo himself was severely burned in the process, fleeing to his brother's residence. Pardo was discovered the following morning where he lay dying from a self-inflicted gunshot wound to the head. No prior criminal history was referenced in any of the articles I reviewed on the case on the part of Pardo. Seal Beach, California, October 12, 2011 at 1:21 p.m. The largest mass shooting in the history of Orange County, California took place. Scott Dreckey, 41 years old, was involved in a highly litigated custody dispute over his young son and had been in court only the day prior. Scott Dreckey shot his way into and out of the hair salon where his ex-wife worked. When he left, dead were his ex-wife, the salon owner, and 4 other persons on scene. 3 were transported to the hospital, 2 later died. 9 people who had never heard of Scott Dreckey before that day died in the ripple effect of his divorce and custody case. There was only 1 lone survivor in this shooting. The body count could have been significantly higher as the father's vehicle contained additional weapons and ammo. The father was wearing body armor when taken into custody by the police a short distance from the shooting. The father pled guilty on May 2, 2014. The penalty phase was still pending on the issue of death penalty or life imprisonment without the possibility of parole in 2017. No prior criminal history was referenced in any of the articles I reviewed on the case, although it was mentioned the father was on medication and was working with a therapist related to a work injury. Payette, Idaho, June 3, 2013 at 6:20 p.m. A young 6-year-old child, upset over his parents' divorce, committed suicide. His death left many in the community wondering, how was it possible that a child so young could commit such an act? In fact, 4 detectives were assigned to this case exclusively to determine if the child did in fact commit suicide. It was beyond the comprehension of everyone in the community that this could have happened. The child had previously been watching cartoons on the TV in the living room. When he walked into the kitchen, taking off his belt, the boy tied it into a makeshift noose and hung himself from the freezer handle of the refrigerator. The child in this story is very unusual because of his age. In fact, only 4 children aged 7 have committed suicide between 2007 and 2013, as referenced in the articles I reviewed. Now, perhaps some of you heard of a horrific homicide just this past week. A mother in Georgia, Maura Williams, has been charged with 2 counts of murder after she killed her 2 young sons by placing them in the oven. Happened sometime the week prior on a Thursday or Friday. The children were only 1 and 2 years old. The mother called the father after the children were dead, showing him live video footage of the crime scene. The father called the police after seeing his 2 young children on the floor. The father said, "It was like a horror movie. It was Friday the 13th when I saw my kid. How I saw my kid. That's when I knew what was going on." Williams' mother said she hasn't been right, and what happened 3 months ago, that's when the kid's father left her. I told him something tragic was going to happen. She's going to do something to the kids. She's going to do something to herself. These scenarios are not limited to parents only, but involve other family members as well.
The drama of an attempted murder.
Gonna go back.
With the drama of an attempted murder captured on the victim's own iPhone. Police say the man was shot by his mother-in-law, but that's not the story.
So on December 9th in Broward County, Florida, a 67-year-old grandmother attempted to kill her ex-son-in-law by shooting him during a custody exchange of her granddaughter. She called the police, and she told the police that the son-in-law had attempted to kill her. He was arrested, then later released, after the video on his cell phone proved it was the grandmother that did the shooting and not him. If convicted, the grandmother was looking at 30 years in prison. In this particular case, additional family members were also arrested. They included the mother of the child and her brother, who had obtained the weapon for the grandmother. No prior criminal history was referenced in any of the articles I reviewed on the case on the part of the grandmother. Now, not long ago, a grandmother contacted me to help her. So let me just play this.
With the drama of an attempted murder captured on the victim's own iPhone. Police say the man was shot by his mother-in-law, but that's not the story she told 911 operators. And ABC's Matt Gutman has more from Miami. Good morning, Matt.
Hey, good morning, Robin. That video is viscerally disturbing. The real-time recording of a man nearly being shot to death. Now, Salvatore Maglino knew to expect some sort of confrontation when he went to pick up his son from his in-laws, so he kept his iPhone rolling. We could have expected this. This morning, the chilling, jarring sound of what police say is a man being shot at point-blank range. You can't see what Salvatore Maglino tried to capture on his iPhone, but you can hear a bitter custody battle playing out. Neither could Broward County Sheriff's Office deputies at the scene moments after.
With the drama of an attempted murder captured on the victim's own iPhone. Police say that.
So not long ago, a grandmother contacted me for help as well on her behalf of her granddaughter. After 2 years, an investigation of sexual abuse was identified as inconclusive. The term used to describe allegations investigated that cannot be proved or disproved. As a result, the father was granted unmonitored supervision as well as overnights with the child. Believing the child continued to be abused, the grandmother, 79 years old, who had never fired a weapon in her life, tried to kill the father by shooting him, and, no big surprise, missed. The grandmother was convicted and sentenced to a mental institution for 1 year. Now, the court in this particular case believed that the child's mother had advanced knowledge that the grandmother was going to attempt to shoot the father and strip the mother of her custody. The child now lives full-time with the father. When the grandmother was released, she contacted me. The grandmother wanted my help in restoring her daughter's custody and providing proof of the sexual abuse, which she still continues to continue till today due to the statements of the child, and this case is pending. The grandmother had never been arrested and had no prior criminal history prior to this shooting. Now, my own research of 10 years has identified that family law may be responsible for 25% of the crime in the United States. That's homicides, suicides, abduction, child abuse, domestic violence, violation of court orders, restraining orders, stalking, and more. To just put one of those numbers into perspective, the National Center for Missing and Exploited Children, known as NCMEC, issued a report that of the 300,000 children reported missing and abducted, 30,000 were abducted. Of this number, 92 to 95% were abducted by family members or persons known to the family. Only 5% are abducted by strangers. Now, this was prior to 2012. After 2012, NCMEC adjusted those percentages to reflect that only 1% of the children who are abducted are taken by strangers. 99% are abducted by family members or persons known to the family. Now, one description provided to inform the public and others just how severe the issue is said that so many children abducted on an average day by family members and persons known to the family, they could fill a school bus every other hour, 24 hours a a day, 365 days a year. As a side note, the belief by the general public and many professionals is that mothers and not fathers are primarily responsible for the majority of the abductions, and it's not true. Mothers are responsible for 25% of all abductions, and fathers were responsible for 53%. And I have to say that statistic also surprised me. Grandparents, aunts, uncles, and other family members make up the remainder of the abductions. Now, just as missing and abducted children are taken by family members or persons known to the family and not strangers, so goes the same with homicides. Most victims of homicides are killed by persons known to them and not strangers, which is why detectives always start with the spouses and the butlers, as the movies so fondly like to say, but it's true. Approximately 3,500 to 4,000 homicides a year are related to family law. Suicide is now the 10th leading cause of death, with rates at their highest right now in 30 years. The increase in double digits beginning in 2006 after falling off and stabilizing in the 1950s. Yearly, there are approximately 10,500 suicides related to family law committed by children and adults. And children comprise about just under 1,200 of those numbers. Now, I cannot definitively say that this percentage is correct. This is the best guess because law enforcement does not track causative factors. But in fact, 25% may be too conservative a number, and the actual percentage may be much higher, especially when you consider the statistics related to child abduction and homicides. Even more disturbing to those of us with a law enforcement background is an increase in the number of child homicides. Children murdered by their own parents in the ultimate act of retribution, revenge, and parental alienation. In 2015, there was a total of 1,853 child homicides. 450 of those children were murdered by their own parents. And that's an average every year in this country. 3 decades of FBI homicide data was reviewed by the Northwestern University criminologists who applied statistical models to the records in reaching this conclusion. Supporting this position is the information that the Department of Justice, Office of Juvenile Justice and Delinquency Prevention publication reported that children under the age of 5 were more likely to die of homicide in this country than cancer. The United States is not alone in these horrific crimes dealing with family law, which are not confined to a single gender, country, or continent. On February 11, 2015, Lennox, Belgium, a 35-year-old mother, in a rage over her husband's attorney, who sent a letter requesting full custody of the children for the father, locked Madison, who was only 6, Abigail, 4, and Umi, 2, in a storage shed. Then, doing the unthinkable, she set the shed on fire, burning the children alive. The mother called the father, holding up the cell phone so the father could hear the screams of the children, and said, "I will never surrender my children to you." The one child that did survive was not home at the time of the incident. She was a child from a previous marriage and on the father's side and not the mother's. No prior criminal history was referenced in any of the articles I reviewed on the case on the part of the mother prior to this incident. Australia, November 2009, the father, Ramsakan Assar, excuse the pronunciation if it's incorrect, was dubbed the Facebook murderer after posting his child's homicide on Facebook. The father stabbed his 2-year-old daughter in the stomach and chest and left her to die in a wooded area. The father sent a text message to the mother saying, "How does it feel not to have your child when I did not have mine for 3 months?" The father pled guilty. No prior criminal history was referenced in any of the articles that I reviewed on the case. There is no shortage of headlines around the globe dealing with family law. They run the gamut from mild to absolutely horrific, and the number of headlines is increasing weekly, monthly, yearly, everywhere, not just here. Social Services conducts 3.5 million child abuse investigations every year nationally, impacting 6 million children. That is more children than the entire countries of Norway, Sweden, Finland, Belgium, Luxembourg, and Denmark combined. Unofficially, however, the number of investigations is closer to 12 million. Much of this is due to cross-reporting by social services with law enforcement, who then conduct a separate and additional investigations from social services. And this is in addition to other agencies such as schools who also cross-report with law enforcement. The goal was to make sure that no child fell through the cracks, that we were all checking and rechecking with each other. In some cases, entities may have multiple layers of investigations even within the organization. This is important because when you consider the number of times a child can be interviewed or go to court, the legal process itself can be much more traumatic for a child than the actual crime, no matter if the allegations are true or false. 40% of all investigations are identified as inconclusive. As stated earlier, this term means that social services is unable to prove or disprove the allegations. 90% of this group is believed to be parents or others acting on their behalf, using investigations to gain an advantage in custody. That's an unofficial assessment, but direct from social workers. Now, I've certainly known many well-meaning parents over the years who, believing their children were being abused by the other parent, wanted to file child abuse investigations. After discussing their concerns with me, not a single parent felt the need to make a report of abuse with social services or the police. Most of the allegations dealt with non-emergency dental and medical appointments, braces, early or late exchanges, homework, which is frustrating to a parent, and it's in violation of a court order, but it's not child abuse. Most importantly, not a single parent has ever regretted their decision. In fact, many parents have often contacted me and thanked me for stopping them from taking such an action which protected their child from unwarranted interviews by one or more agencies, providing for the possibility that well-meaning parents, although overly emotional during and after a divorce, as opposed to an alienator, that it may be possible to reduce the number of child abuse allegations filed with social services and law enforcement with proper education and guidance in these cases. This could provide much needed relief to social services and allow the reallocation of manpower to valid allegations that do fall within the scope of social services. Driving some of these points home even further is the estimate that we may now be spending as much as $1 billion a year on restraining orders alone in this country, especially when you consider the advantages to the alienator, because it can take a parent months, even years, to reestablish custody in dealing with false restraining orders, false allegations, and multiple arrests, even without a conviction, if at all. Case in point, Lake County, California, February 16, 2016, Luther Jones was convicted of child molestation in 1998, and he was released from prison 18 years later. During the trial, Jones argued that his wife was trying to set him up because of a custody dispute over their 10-year-old daughter. The jury did not believe Jones, and he was sentenced to 27 years in prison. In 2016, his daughter, who was then 30 years old, contacted the district attorney's office and recanted her story, saying the mother had coerced her into making false statements against the father. The father's release was expedited due to severe medical complications, and he died just a few months after the release. No prior criminal history was referenced in any of the articles I reviewed on the case prior to the father's conviction. In response to this specific case, the Lake County District Attorney's Office set up a unit to prosecute persons committing perjury, claiming that this was an epidemic in the court system with no consequences. This is the first such unit anywhere in existence in this country, to my knowledge. Think false allegations is applicable just to the United States and nowhere else? Wrong. In Canada, a police officer was convicted of child molestation and was released under similar circumstances after serving 19 years in prison when his 2 adult children recanted their stories. These are just a sampling of the stories that make headlines, but many don't. False allegations are escalating in family law. One client of mine has been arrested 3 times over the past several years for false allegations. He would have been arrested more if the other parent had their way. Even now, the parent is facing new allegations and may yet be arrested again. The hearing on the restraining order occurred just a few days ago and was not granted. No charges have ever been filed against the mother for the false allegations. LAPD is not without their own shared grief in dealing with family law, as officers in their private lives are not immune from the same stress of divorce, custody disputes, and false allegations as the public. Some spouses have taken advantage of the department's internal complaint system to file false allegations against an officer, applying even more stress during a police divorce, as we call them, than what the public faces. So you have the public with one layer, and then you have the police and military as well that have another layer. And these trigger additional layers of investigations against an officer. Even with the finding of innocence, these investigations can be overwhelming to officers, impacting their ability to be assigned to special units and promote. If the officer is assigned to the field or is in an undercover position, if they are distracted at the wrong moment, it can spell disaster for everyone. Even the completion of a police report with the wrong street name or address can result in allegations of perjury if the officer makes a mistake due to the distraction of a pending court date, and officers have gone to jail for honest mistakes on reports. Several officers under the stress have committed suicides over the years related to these issues. I have personally known some of the officers who committed suicide. One officer took his life while in uniform in the police parking lot. Another took his life in a hotel room with a shotgun. He did not want his children to discover his body or leave them with the memory that Daddy died in this room. He even covered the floor in the hotel room with plastic so that when he slumped forward and fell to the ground, he would not bleed all over the carpet. LAPD is not an exception in these situations. In 2016, 108 officers took their lives. Now let me try and paint another picture of another area of family law that is difficult, because once a cop, always a cop. On weekends, police stations look more like child care centers, Friday, Saturday, and Sundays, as families seek the safety of the station where officers are present and can keep the peace for morning, afternoon, and evening exchanges of the children. Domestic calls where family members they'll actually scratch themselves, strike themselves with objects to create marks and bruises, then blame the other spouse in order to seek an arrest, all in an attempt to gain an advantage in the divorce and custody process. I'm only speaking I'm not speaking exclusively of men here in these scenarios, by the way. Women in growing numbers are going to jail not only on domestic violence allegations, but are going to prison convicted of child abuse. I've been approached several times to work on such cases, one as recently as last week, where a mother went to prison on 2 life sentences to be served consecutively and referred to me by Joan Clark-Zenard, who is already involved. The case is pending. Another all too frequent occurrence is the one in which patrol officers are provided with a copy of a court order by one parent, then respond to the home in the middle of the night to take custody of the children per the court order, only to learn that that court order was replaced by another court order, one in which the children were to be returned to the very parent officers were there to take the children from in the prior court order. And the parent who contacted the police willfully and intentionally withheld this information to mislead officers in an attempt to leverage law enforcement to take custody of the children from the other parent. Or the radio calls for officers to stand by to keep the peace as a mother or father must hurriedly grab their clothing after being told to leave the residence due to a restraining order, or later, following the divorce settlement, when furniture and other personal items have been divided and it is anticipated that when they pick up these items, there could be problems, and officers are requested to stand by. There are no shortages of these and other scenarios as officers respond to radio call after radio call after radio call every day of the week. In fact, on some days, for hours on end, 100% of all radio calls are related to custody. Christmas Eve, Christmas Day, Mother's Day, Father's Day, start and end of school breaks, summer, winter, spring. More now that we have year-round schools. In these scenarios, custody goes to whoever can take it or keep it. Law enforcement is absolutely not prepared for today's brutal, devastating divorce environment where nothing is off limits and all is fair in a war called divorce and custody. Burglaries, withholding of custody, perjury, parental alienation, and more. Where false allegations of child abuse, false police reports, and false restraining orders are seen as tactical necessities. Where the last one standing who looks the best, sounds the best with an attorney is the winner. Where parents suffering from post-traumatic stress disorder are unable to protect themselves during investigations because they are unable to communicate well during questioning with police and social services. For that matter, communicate well in counseling, mediation, or evaluations, which has really been covered repeatedly, but especially struggle in testifying in family law and criminal court. PTSD and the inability of a parent to function is an intentional act sought by the alienator and accomplished through numerous filings of motions and court dates, now known as legal abuse, along with the other actions already covered, all with the specific goal to break the parent emotionally, financially, and physically, along with severing the relationship of the children. Which is why parental alienation really is a form of domestic violence, lacking the physical proximity to their victim. Alienators have simply adjusted their tactics to the environment, exercising power and control outside the traditional forms of physical and domestic and emotional domestic violence. Many parents are blindsided upon entering the family law process. They are naive about their rights, believing in the system's ability to recognize the difference between a truth and a lie. We can't tell you the number of times parents say that to us. I thought they could tell the difference. I thought they would know I was telling the truth. Family law, as I tell parents all the time, is counterintuitive to everything they believe about court. Parents just don't realize how much they stand to lose until it's too late, nor can they imagine just how far the other parent is willing to go, including sending them to jail or prison to win everything and take custody. We are a flawed system, and we make mistakes, too many mistakes. Law enforcement, family law courts, all of us. Parents too, which is why parents need help. They need better advice. They need more information to make better decisions. They need to be much more cautious in their dealings in and out of court, as well as their everyday interactions with the alienator, with their attorneys, and with their money. And they need that sooner rather than later. This is why, after 34 years, from my perspective, parents need a team. An attorney alone is not sufficient. Attorneys are not trained to facilitate or maintain the relationship. to maintain a relationship with, between the parent and the child, giving it parenting advice, to keep a parent sane, which, by the way, is getting pretty tough nowadays, in my opinion, especially in today's divorce environment, or the million other issues that come up outside the courtroom. In fairness, nor is that the function of an attorney. What else has changed in the family law divorce environment? I tell parents that in addition to family law attorneys, they'll need a criminal law attorney in many instances. 2 attorneys will need to coordinate with one another to ensure that nothing they agree to in criminal court will jeopardize custody if they take a plea bargain. And now I'm going to tie it why this is so important. As well as an attorney that would specialize in social services. It is rare to find a single attorney with all 3 backgrounds. And just for the record, you cannot imagine the number of parents who, overwhelmed, make the decision to accept a plea bargain. Not because they've done anything wrong, but out of necessity as they see it, because they need to address so many issues in family law, but also because they've lost all belief in the court system that they will be found innocent. So they take a plea bargain because if convicted, they could go to jail or prison. It's the lesser of 2 evils, if you will. Something else that has changed too in family law and is gaining momentum quickly is that in years past, false allegations followed after many agonizing years of frustration, litigation, and untold number of court dates, followed by a huge emotional toll and legal fees, all in an effort to either keep or take custody in a winner-takes-all scenario. From the alienator's perspective, why spend years to obtain custody when they can be awarded custody from the onset with just a few false allegations, restraining orders, and a few court dates, and for very little money? With no downside, what is there to lose? Because nobody prosecutes for false allegations, nobody prosecutes for perjury, nobody prosecutes for false police reports, and there's no consequences for false restraining orders either. Even though there's a penal code section in nearly every state that says these are all punishable. So even if they're caught filing a false allegation, it is a rare parent that finds himself facing any consequences by law enforcement or the courts, which is just as frustrating for us. Which is why false allegations is now the opening salvo. The first step is being the shortest, quickest, least expensive, and most effective route to sole legal and physical custody. Now, let me be clear. I am not saying that valid allegations of abuse do not occur during divorce proceedings. They absolutely do. I am addressing only false allegations filed in an attempt to gain an advantage or later in continued litigation dealing with the children. And I'm aware of the time. Law enforcement is just not equipped for this level of warfare, as there's another scenario which is rarely addressed. That is the natural bias ingrained in every officer, which is the protection of a child, especially when the abuser is a parent who is supposed to love, protect, and cherish their child. It is the worst betrayal possible in the mind of an officer. So as much as an officer or a detective may discount some of the statements of a child because you're involved in a divorce, a child can be very convincing, especially a child of parental alienation. As a result, a parent can quickly find themselves being arrested and convicted of false allegations as already identified, not just here, but elsewhere around the globe. In 2008, the Los Angeles Police Department issued Special Order Number 40. This order curtails the taking of police reports dealing with custody and for many other issues in family law, the exception being some crimes such as abduction. Known by different names, Special Order Number 40 exists in nearly every law enforcement agency in this country. This hands-off policy in dealing with family law is the result of several scenarios. Accusations that officers were favoring one parent over the other, court orders being read and incorrectly applied has resulted in millions of dollars being paid out over the years by many agencies, not just the LAPD, and complaints filed against officers by parents cost the departments hundreds and thousands of dollars in man-hours and personnel to investigate. The result for LAPD was Special Order Number 4 and the phrase which has become so well known by so many parents. This is a civil matter. You need to go back to court to resolve this. In reality, LAPD was one of the last few agencies that continued to take police reports long after smaller departments had stopped. Now, I am aware that I've now hit 50 minutes. Some of the technical problems and maneuvering there has used up some of my time, but let me just address, if I could, 1 or 2 more minutes.
We can cut it.
Okay, I'm sure it comes as no surprise to anyone in this room that officers, detectives, and civilians of the Los Angeles Police Department receive no training on divorce, high conflict cases, or parental alienation. I am unaware of any law enforcement agency, for that matter, that provides training on these issues anywhere else in the country. Okay. So, there's one thing I want to close with, one more example. Even without arrests, many parents develop medical issues related to the stress of their divorce. Not long ago, one of my clients died from medical complications from a traffic accident they had been involved in during the divorce. The death certificate, however, should have read, died from a broken heart. They had been in court 48 hours prior to attempting to keep their attorney on their case and lost. I personally had clients that were unable to put 2 sentences together and had to communicate through relatives until they could function enough to communicate with me directly. Other clients who were so overcome with their emotions at just the thought of entering the process, they had to mail me their divorce papers, which I then forwarded to their attorney. So, none of the parents referenced in any of this presentation had any criminal history prior to entering the divorce and custody process, even in cases involving parents who murdered their own children or the other parent. There was no criminal history, which begs the question, are parents susceptible to these scenarios given the right environment, or have the courts literally driven parents to these behaviors based on the method and manner in which family law court functions, or both? Don't we owe it to families to get these answers? In closing, I want to borrow a line from, go through this form. So a famous line I'm going to borrow from Huffington Post: marriages come and go, but divorce is